Okay, I'm very happy to present our next speaker, Geoffrey Hoffman, who's a clinical associate professor and director of the immigration clinic at the University of Houston Law Center. Jeff has a degree from Columbia University, his JD from Tulane, and his LLM from Harvard Law School. He specializes in immigration-related federal court litigation, deportation defense, asylum cases, and the reason we brought him here today, appeals before the Board of Immigration Appeals. He has served as co-counsel and counsel in over 48 appellate and trial court cases. Professor Hoffman served as co-counsel before the Supreme Court in the precedent-setting immigration case, Rosendo versus Holder. Prior to joining the immigration clinic, he practiced immigration law at Curzon, Wanger, and Petzelli, you can correct me, in Miami. He personally has received numerous awards, and the Law Center Clinic has, under his leadership, received the Pro Bono Hero Award for the Central Region by AILA for 2015. I had the pleasure of working with Jeff several years back on an SIJ case. It was an emergency ADAP case, and nobody wanted to take it, and he did, and we were able to get the child into the URM program. So I'm forever grateful to him for that. Without further ado, Professor Geoffrey Hoffman.
Thank you. Welcome back from the break. Thanks for coming to my talk. It's a pleasure to see a bunch of friends in the audience. I want to point out Professor Janet Beck, who works with me closely for many years, is here. Is Josephine here? I want to point out my other staff attorney who is not here. And thank you to Sela and to Yasmin and Dahlia for all the great work that they do and for inviting me. And I'm always available to you guys if you ever need anything. Anyway, let's get started. Today I'm going to talk about perfecting the BIA appeal, and I'm glad that you asked me to speak on this topic because I actually know something about appeals. Because that's what I started out doing in Miami when I worked for IRA, Kurzban, and I continued doing that here in Houston. And so pretty much I've been doing that for the last 13, 14 years, whatever it is. Oh, and let me just also thank Ayla. I found when I was preparing this slide, I found an excellent PowerPoint from Ayla, and I liberally took a lot of information. Some of it is my information, obviously, that I've information that I've learned and strategies. I'm going to give you some tips of some strategies that I use on my appeals. So that's parts of mine, but a lot of it's Ayla. And just organizing the site. So I want to, and I asked them for permission, they said fine. So with that, credit, we'll move on. So let's start with the notice of appeal. Pretty basic. How many of you have done appeals? So good number of you. Good. Okay. So I don't have to tell you then about the notice of appeal. You know it's the EOR 26. The most important thing for me when I do the EOR 26 is, and you know, those of you who've done appeals know this, is the reasons for appeal. So some people have different strategies to do reasons for appeal. Some people say, reasons for appeal, see brief that I'll file in 3 months. But that's not a good idea. I wouldn't do that. What I learned when I worked for IRA is to make the reasons for appeal very, very, very detailed. And what I even do is say, see attached, and then do 3 or 4 or 5 single-space pages that discuss not only the reasons for appeal, but, and there's some slides coming up in a second, but also relating to why the case should not be dismissed summarily, why you want a 3-member panel versus a 1-member panel, and various other technicalities like that. So I would advise everybody do that in their reasons for appeal. There's a $110 fee or a fee waiver request. The form is EOR 26A. I always do an affidavit of indigency as well, just to kind of spell out what's happening and why they can't pay the fee. And then, as I say here, practice pointer, argue against summary dismissal, because it's very possible if you don't have any reasons for appeal or if they don't make sense, then guess what? You won't get a chance to do a brief. It could be summarily dismissed, and that's very bad. Some more on the notice of appeal. Remember, it's a very strict time period. It's jurisdictional, so you can't miss that 30 days. And some people think, oh, I'll just get it in 30 days. As long as it's 30 days. When I sent it, I sent it on the 30th day. No, it has to be received by the BIA by the 30th day. So there's no mailbox rule. 30 days starts from when the decision was issued. So some people might say, oh, but I got it, 2 weeks after it was issued, so I can count the 30 days from when I got it. No, it's when it was issued. And so that's the date on the IJ's order. It's not even the date of the hearing. It's the date that the IJ put on that order. So if you're in court and the judge puts the wrong date, make sure you object and say, Your Honor, may you please put the right date. And then you might get yelled at. But still say something. You must have EOR 27. Everybody knows about the notice of appearance. Even if you were counsel below. So you may think, oh, I was the attorney in front of the IJ. It doesn't matter. BIA needs your new notice of appearance. Don't forget proof of service. And the forms are downloadable. Okay. BIA issues a receipt and notice. Now, here's a good idea. I must admit I don't do this in all my appeals, but it's a good idea to do an EOIR FOIA to get the full record because it may come faster than the transcript. And also, if you were not the attorney below, you're not going to have all those records. You're not going to have all the exhibits. You're not going to have, any of the, for example, decisions that may have been rendered by the judge or notice of hearing, stuff like that. You're not going to have that, so it's a good idea to do that. It'll also give you a paginated record, which is easy to work with, and also where the case came from another attorney. Sometimes the other attorney doesn't have a complete record, so it's good to do it for you. The BIA, although will send you a transcript. That'll have the transcript and the IJ decision. And that's about it. So again, you won't get all of the documents that were filed by your client. So you have to either get it from the prior attorney or do a EOR FOIA. Check the transcript very, very, very carefully. I've won a few, maybe 2 or 3, appeals based on transcript mistakes. And one time I had a case where it had been up to the BIA maybe 2 or 3 times, and I took over the case, and I got the transcript from the board. This is back when they used to send you the cassette, and it was missing cassette. And so I objected. I said, never got the cassette. I mean, I got there's 6. I got 4 of 6. And so I got a remand on that basis. And they had just lost it. They just lost the cassette. Everybody knows you can request 1 extension. Everybody knows that. And you're basically entitled to 1 extension, but that's it. So it's a 21-day extension. More than that is usually not. I've tried before, but not going to be granted. So it's a 21-day briefing schedule. You want to file a response brief if it's not a simultaneous briefing. I think what that means by response brief, it means a reply brief. So after you do your simultaneous, you can do a reply. I usually do a motion to accept the reply and also file the reply if I want to make more points on a simultaneous briefing. Board will not delay adjudication to wait for your reply brief. Okay. In non-detained cases, it's a little different because it's not simultaneous. So you'll file your brief, and then there'll be whoever the appellant is will file a brief, and then there'll be some time, usually 21 days, to file a response brief. There are very messy cases with cross appeals, and those are always very difficult to figure out who files the brief first. Extension of time. Everybody should be aware of the BIA practice manual. Everybody know about the practice manual? It's online. It's a really good resource, and you need to read it very careful because if you don't, you'll miss important things about the procedures in the BIA. Okay, so here are some strategies to avoid summary affirmance. This is very, very important, and like I said before, I always include some argument in the reasons for appeal in the OR 26 that relate to this. So you want to argue that these things don't apply. So you should not have a summary affirmance. So it's possible that it will be a summarily affirmed if the error was harmless, the issues are rarely controlled by case law. So you're going to argue that if there was an error, it wasn't harmless. And you're going to argue it's not rarely controlled by case law. You're going to argue there's substantial factual and legal issues. Strategies to avoid summary affirmance: argue issues not squarely, okay, we talked about that. Argue the issue is substantial or novel. Argue that remand is required. So this is interesting because remand is a good technique, and I'm going to get to. I have a slide, the most important slide. I'm going to tell you the most important slide coming up, which is I shouldn't say that because then you say, well, it's not important. But there's the really important slides coming up, and I call that the slide on background issues. So this is touching upon something called background issues. The BIA cases I've won, is part of the little strategy lesson. I've won them on the background issues usually, and I'll tell you what I mean by background issues. But this is another potential background issue. We're beginning to start to talk about this. A remand based on the fact that further fact-finding is necessary may be very persuasive to the board. Because if the board thinks that the IJ didn't do a good enough job of developing the record, that's a constitutional problem. Everybody shout out. What part of the Constitution? That would be a problem? Go ahead. Somebody said it. Due process. That's right. Okay? So remember that, because even though some of us may not believe it, some immigration judges may not believe it, there is what in immigration court? Due process. Okay. Trying to make it interactive. Strategies for obtaining a 3-member panel. So again, in your reasons for appeal, what are you going to do? Avoid summary judgment. Try to get a 3-member panel. So basically that you want to have this in your beginning of your brief and also the notice of appeal. A case needs to have a 3-member panel if the following things apply: settling inconsistencies among the rulings of different immigration judges, establishing precedent regarding the meaning of law, so interpretation, review a decision by an IJ that was not in conformity with the law. This is one that obviously you want to harp on. It was not in conformity with the law or the precedents. And then you discuss what precedents you're relying on. Okay. Issues of national or major national importance, clearly erroneous factual determinations. We're going to have a slide on the standard of review. Very important. Another tip, to be very cognizant and sensitive to the standards of review. If your judge got the standard of review wrong, or the burden of proof wrong, and then the standard of review on appeal is such that you can use that to get a de novo hearing, a de novo review before the BIA, you want to harp on that, because the de novo review is a lot better than the clearly erroneous test. Remember to argue against the member review if you won in the immigration court. Everybody got that? If you won in the immigration court. So a lot of clients, you win asylum and say, oh, I'm so happy, I'm so glad. And I say, don't be happy, don't be happy. So I don't mean to be, mean to you. I'm not being mean. I'm being honest with you. Don't be happy until what? Until 30 days pass. Because guess what? The government will, in many cases, file an appeal. And if they do, then where are you on the other side, on the BIA? So this is basically just another, I think we've already discussed this, strategy to avoid AWO, affirmance without opinion. It's similar to a summary affirmance. Now, I also put the next two slides I put in here because I really, when I teach for immigration, I teach asylum, and I teach the immigration clinic, and I like to discuss motions to reopen because some of you who are doing immigration, or even if you're doing other stuff, but you're doing pro bono immigration, be very sensitive to motions to reopen, because if you really understand motions to reopen, a lot of times somebody comes in with a final order, and a lot of attorneys say, I can't help you. I'm sorry, you have a final order, okay? But if there's some argument that you can file a motion to reopen, then you may be able to help them. And that's for pro bono counsel and also private counsel. So the general idea, so if I put my glasses on, I see better, but I don't. I'm getting so old I can't even see with glasses. The 90-day rule, so there's a 90-day rule, okay, to file the motion to reopen after the final order. But then there's exceptions. So what are the exceptions? Change country conditions for asylum cases can be filed. There's change country conditions filed at any time, as long as it's within a reasonable time of the change country conditions. Lack of notice, file at any time. If your client really actually never received notice of the in absentia order. In absentia orders only, you have an extra period of time. You have 180 days, okay? But that doesn't mean that you can reopen it after 180 days. Within 180 days, you still have to show what's called exceptional circumstances, okay? And what is that? Well, you have a whole course on what that means. There's no automatic stay, so they won't stay the deportation, except if it's a lack of notice case, so you have to file a what? Motion to stay, that's right. So the point is, and this is the same, so we talked about, remember I mentioned motions to remand? It's the same standard for motions to reopen. The standard is very clear, and this is why a lot of people get their motions to reopen denied. Why do they get it denied? Because they don't show this. New evidence which could not have been discovered or presented at the time of the original hearing. So they may have new evidence, they may have new claims, they may have married U.S. citizens, they may have changed country conditions, and they'll still lose their motion to reopen. Okay, why? Because you also have to show why it was not reasonably available. Why, for whatever reason, be creative, why it was not available at the time of the hearing. Another tip on motions to reopen, they will deny your motion to reopen if you don't attach what? The application. Somebody said that? Okay. The application for don't forget, if it's a new motion, if it's a new asylum, attach the 589. If it's a matter of larger Pacheco, which they got married to a U.S. citizen, attach the I-130, I-45. If it's whatever it is, attach that out. Copy as an exhibit. So be aware that if all else fails, and I've done this too, some of you have done this too, and there's no the time bar, there's number bar, everything's barred, and there's no chance of reopening because you're outside the 180 or 90 days. There's what can you do? Sua sponte. First, you go to DHS and ask for a joint motion, and they'll tell you no. No, they may say no. They may say yes. If they say no, then what do? File sua sponte. And this works really well for change of law. If there's been an intervening change in the law, like Carachuri, or like we just saw Mathis, a good example, and it just changes the landscape, you can get it reopened sua sponte. Motions to reconsider. So don't confuse these two. On my law school exams, when I grade my papers, I see one of my students up here. So I'm not talking about you guys, but on my law school exams, a lot of students confuse motions to reconsider with motions to reopen. Motions to reconsider is very different because it's within 30 days. There's no number bar. In other words, you can file as many of them as you want after each decision. It doesn't have to be a final decision. It can be any decision the judge makes. You can reconsider. The standard is that there has to be reconsideration reconsideration was warranted in light of additional legal arguments or a change in the law or a case or authority that was overlooked. So it's very narrow, and it's not going to be based usually on the evidence, although you could try if you get new evidence and try to argue, but it's mainly going to be a legal question. And I've had this problem before too. Be aware of the effects of filing a notice of appeal. So you get really excited. Oh, I'm going to go to the BIA. I'm going to challenge this guy, this IJ. I'm so upset. File my notice of appeal on day 2. But then I think, wait a minute, I should have done a motion to reconsider. I have a really good argument for changing the law or a precedent that the IJ overlooked. Well, guess what? You go down to court and you talk to Will. Everybody know Will at the AOIR? Shout out to Will. Hey, Will. I hope Will likes me. Sometimes he gets frustrated with me sometimes. So I'm giving him a shout out. So you go down and talk to Will, and Will says, I can't accept your motion to reconsider. And you say, why? Because you lose jurisdiction. Once you file that notice of appeal, they physically take the physical file and they send it up to the board. And you feel really foolish, and you have to explain to your client why you filed a motion that cannot be even considered by the IJ. That happened to me one time. All right, now these next 2 slides are the crux of the, it's like when I teach for immigration, I say there's the crux of the course. I shouldn't say this anymore because students are like, well, if that's the crux, like what's the rest of the course? Why are we even listening to the rest of it? But this is the crux of this lecture, is the brief writing tips. So I can see it, I'm going to use my notes here. So I guess there's a lot of things you could say about brief writing, and I have like a little lecture that I give in the clinic. I have a whole day where we talk about legal writing and immigration. It's kind of interesting because I don't think anybody's really like published a book on that or law review article. But it's a really good idea to understand that as immigration lawyers or practitioners who are doing pro bono cases on the side, it's really good to know some of these little tips about immigration that's specific, idiosyncratic to immigration, because it is very different than any other type of law. So the first thing is pretty obvious, everybody knows, which circuit case law controls. A lot of times students will write a brief and they'll be talking about the Ninth Circuit. Dahlia talks about the Ninth Circuit. And by the way, Dahlia worked for the immigration clinic, and she won a BIA appeal and did an excellent job. So I just want to say that. Well, did a great job. So maybe you should be teaching the BIA appellate stuff. Anyway, the most important thing is the circuit case law controls, and that's determined by where the IJ's final decision was decided. So, you know, sometimes people get confused and say, well, the NTA was filed in California, and I'm going to use Ninth Circuit, but you have to figure out where it was decided. Now, there are some interesting and strange situations where you can argue, let's say it's telephonic or video, and let's say it's a IJ in Virginia. Professor Beck had a case like that, and the person, the respondent is sitting in Port Isabel. You know, can you argue that it's, you know, whatever Virginia is, Second Circuit, whatever it is? Probably not. It's probably going to be where they're sitting by designation. But again, think about that. Usually for us here in Texas, it's going to be Fifth Circuit. Think carefully about relevant issues and discuss in the order most likely to succeed. So the issues are very important, obviously. One of the big problems is don't make your issues too verbose and too complicated. Try to make it very simple. Now, these guys in the board, these people on the board, they're obviously immigration people, but they also don't have a lot of time. They have thousands, tens of thousands of cases. So they're going to be looking through your brief. If they don't understand it right away, then you just shot yourself in the foot. So make it try to boil it down to the very, you know, simple, succinct as possible, and try to boil it down to 2, 3, or 4 issues. Now, of course, I've violated this rule many times, so I say that because sometimes we have 6 or 7 issues. And there may be a reason to have 6 or 7 issues, but try to keep it down. Now, here's my favorite part of this discussion. So, background issues. So, even though they may not seem to be at the forefront of the IJ's decision, they may not even have been discussed by the IJ. Maybe nothing in the IJ's decision related to these issues. Guess what? You can win your appeal based on background issues if there's a positive. Okay. So here's an example. This is actually my first, I think it was my first appeal I did, many years ago in Miami. And it was a Haitian mother and her 10-year-old child who was deaf child. Okay. So the pro bono attorney did it below. I got the case on appeal. I read the transcript, and I was thinking about it. I read it very carefully. And I was thinking about it, and I said, I know the kid's deaf, but there's absolutely no discussion of the child in the transcript. No discussion. And it was all about the mother and whether or not she was a member of Lavalas. Some of you know Haitian cases, and it was all about past persecution, well-founded fear of future persecution, and whether or not she was a member, and does she have an ID card, and the judge is yelling at her, where's your ID card? Show me his ID. But no, we don't have an ID card. So then she got an ID card somehow, but the ID card had a misspelling of her name on their name, and he said, well, obviously, that's not you, because they misspelled your name. And she said, but they don't spell, there's no consistent spelling of my name. Anyway, so that was what the IJ's decision was all about. It was all about her credibility. And I thought, you know what? Maybe I could do a motion to remand as part of my brief, because I can argue that the pro bono attorney never raised the real issue, which is that she's a member of a particular social group based on the disability of her son. And I've never done that before. I thought, that's a long shot. Maybe this won't work. I got experts. So in my motion to remand, I got, I would say 5 experts. I got professor from Gallaudet University. I got somebody from University of San Diego who was an expert on deaf education. I got all kinds of experts to say that if you are a kid and you go back to Haiti, they will literally rip out the hearing implants and sell them. I mean, and terrible stuff. I mean, real terrible stuff. So I won the BIA appeal, got a remand on that basis. Went back to the IJ. Then I was able to get the case terminated because she was never given a chance to file affirmatively with USCIS, and then I won in front of CIS. So the case went from being a pretty much a total loser, because you got a credibility issue, which, as we know, judge rules on credibility, your chances are very low. So I found a new issue, got a remand, got it terminated, and then I won in front of CIS. So that was my first thought, wait a minute, I better look for background issues on all these appeals. What are some other background issues? Well, transcripts. So one time I had a Rwandan case where I got a remand because the transcript was so incredibly bad, and I was actually representing the client with IRA in front of the IJ, but on appeal we saw the transcript. And so this is literally what the transcript said. Mr. X, testifies, I was in Rwanda and I faced inaudible. He came at me with an inaudible. I was carrying inaudible amount of money. I mean, it was peppered with inaudible, and what had happened is the interpreter's accent in English was so bad that the person transcribing it just couldn't understand anything. And so it wasn't a problem, it's interesting, it wasn't a problem with the translator, because the translator understood Kinyarwanda and was able to translate, but then the problem was the relationship between the translator and the transcriber. And so one of my big parts of the brief was, there's no record here to be able to make an intelligent decision on appeal, and I got a remand. And luckily on remand we got a new judge, and the judge granted the whole case. So I can't really take responsibility. The judge passed away, who's not the case. And then we got a new judge, and that judge is the best judge in the entire country. So I can't really say that I won that case. It was more of the fact that the judge who was against our client from the beginning passed away. Not that I'm not saying that's a good thing, but other issues that are background issues, if there's relief that was not raised below, and again, if you can show why that relief was not reasonably available or why it was overlooked by the other attorney. If worse comes to worse, and again, we hate to do this, but if you can file a Lozada motion on appeal, you can still do it on appeal as part of your motion to reopen and, comply with matter of Lozada. Basically, anything that's not in the forefront, in the foreground of the IJ's decision. It could be information that was misunderstood by the IJ, or the record was misunderstood. It could be a wrong standard that was applied. Whatever it is, harp on those and use those to get a remand. Okay, let's go to my second most important slide, is the continuation of briefwriting tips. So obviously, it's really important that you have all the salient parts of the brief, the categories that's laid out in the BIA practice manual, and you can look at chapter 4.6. Most importantly, I like to do the standard of reviews, recite what those are, and we have a slide on that if you don't know what those are already, but basically, what do you want? You want to have as much as possible be de novo, because if you're the appellant, you want the BIA to look at the judge's decision anew, afresh. So you want to state that very clearly in your standard of review section. You want to note if there's any burden shifting below. You want to note the applicable statutory framework. So sometimes I even do applicable statutory framework or statute, applicable statute. And then I just talk about, or I quote statute up front. Obviously, factual background is really important, procedural history. This is very important. I had a student, I won't say her name because she was a very good student, but she was very, very smart, very, very, very intelligent. And she gave me a brief. It was an excellent brief, actually, and it had a great factual background. But it was like 15-page factual background. But I was reading it, and I thought, I don't remember some of these facts. It's a really good brief, but I don't think this. So then that made me go back and I checked everything really carefully, and she was exaggerating a lot of facts. So, and they weren't wrong. It wasn't that she was making up the facts. It's just that they were just a little bit exaggerated. So nothing hurts credibility more than misstating the facts or exaggerating them, or referencing testimony or evidence that was not in the record below. Okay, don't do that, because if you're caught doing that, your credibility on appeal goes out the window, and you'll lose very quickly. So I called her in, and we had a discussion, and she went back. The best way to ameliorate this is by citing every single statement in the facts. And I know that sounds like a lot. People are like, well, why? It's so much. How am I going to, cite every single fact? But that's what I do to keep myself honest and to keep the students honest. I just say, look, if you're citing to the record, you need to say transcript at 49. See affidavit paragraph 2. See blah blah blah. So get into the habit of doing that. Remember, you're the master of the facts. So sometimes students put all these bad facts in up front. Committed this crime, did this, string of arrests, prostitution. I say, you know what? That's okay. We can mention that, but that's going to be in a footnote. Okay, somewhere, maybe on page 95. But you are the master of the facts. You create the narrative, and you want to put your best foot forward. And so you create the narrative, okay? Remember, interesting thing about immigration law, it's obvious, but think about it when next time you're writing a brief. We're lucky, we're very fortunate in immigration law to have really, in most cases, sympathetic clients, okay? So use those facts, make it as sympathetic as possible. If there's a medical issue, talk about it. If there's abuse, if it's a abused spouse, discuss that. Cite to the record, cite to the police report, cite to the death certificate, cite to the country conditions. Put all that in your facts, because that's part of the facts. Sometimes people think, oh, the facts are just that he's from Honduras and he entered on this day. No, you want to talk about the whole case, and you also want to mention the experts. So if there were experts below, don't leave those out of your appeal. If the judge, you had a good expert and the judge didn't let that expert in, that's a potential issue on appeal. Or even if you let them in and didn't consider the testimony, make sure you put that in your facts. Okay. So it's confusing to a lot of people. I know some students get confused about what you're limited to on appeal in terms of the facts or the record. So when are you not limited to the record of proceedings below? Because the general rule is what? You're limited to the record of proceedings. And the board is not a trier of fact. We know that. And they'll even say in a lot of my appeals, thanks for submitting all these new facts, but we won't review them because we're not able to hear new facts on appeal. However, in limited circumstances, remember that the BIA may, according to 1003.1d, the BIA may take administrative notice of commonly known facts. Now, what's your definition of commonly known? I don't know, but it's not defined anywhere. So you can argue something is commonly known. If there are new country conditions, well, those are commonly known. If ISIS is overtaking a country, well, that's known, and I would argue that's something that the board can take administrative notice of. If there's new law in that country, if there's something that was widely reported in the New York Times, commonly known. Also, when I do a motion to remand, and this goes back to the first slide, if further fact-finding is needed to resolve the issues, or if the motion to remand standard is met, remember the standard? Material evidence not presented below that was not reasonably available. If you can meet that standard, then do a motion to remand and ask for further fact-finding. Tips before appeal in front of the immigration court. So this is a good slide because when I get the appeals, when I'm doing a lot of these appeals, it can be really frustrating. When it's an asylum case, I had one, some of you who work with me probably remember this case. It was one in front of the IJ, I won't say her name, and it lasted 45 minutes, maybe an hour. It didn't last very long. And the problem is the attorney who did it, the private attorney, didn't develop the record, didn't prepare the witness, didn't have the wife take the stand, didn't have the adult children take the stand. She only had the husband take the stand. And so these are some tips before the appeal, before you even get to the appeal. If you're representing somebody, make the job of yourself, if you're going to take the appeal, or make the job of the appellate lawyer a lot easier. And here's what you should do. Don't forget to preserve the record. Make objections. They're going to yell at you. The judges are going to yell at you. I've been yelled at. Probably every court I've been in, somebody yelled at me. But that's okay. If you want to yell at me, go ahead. That's fine, because it doesn't matter as long as you grant the case, right? I do the best job I can for my client. And some people say, I'll never object to a judge. I'll never, ever can object to a judge. The judge can get mad at me. But you know what? The judge will respect you more if you make a respectful objection. So make your objections, because guess what? If you don't make the objection, it's waived. Put your request for continuance on the record. Do written requests for continuance. If you have interpreter issues, make clear. Don't just accept the interpreter. One time I had a Rwandan case where the interpreter came on, and the family members were sitting behind me, and they tapped me on the back, and they said, "We know that guy. We recognize his voice, and he works for Kagame. He works for them." I said, "Your Honor, objection." The judge was like, "What is it now, Mr. Hoffman?" "Your Honor, objection. I can't have that interpreter." "Mr. Hoffman, you're objecting to the interpreter? Who does that?" "Your Honor, I have to sidebar. So I got the interpreter stricken. And if I was afraid of making that objection, then it could have been very bad for my client, right? Because the interpreter is listening to all of the testimony and allegedly is part of the government or has ties to the government. Request to supplement the record. You can always supplement. You file a motion and then you get something else. You just do a motion to supplement and then attach everything to that motion. Do a proffer of evidence. I think in immigration court we don't do this enough. If the judge, I know Professor Beck has a great story about an expert she tried to get in, and the judge wouldn't let it in. And then she said, well, I'll do a proffer. And I'll tell you exactly what he would have said. You have to do a proffer, which means basically preserve all of that testimony for the appeal. Question?
Yeah, what if you have a judge maybe not saying he's not going to let it in, but just kind of politely urging you not to present another witness? You know, we don't really have to really need to hear from this person.
Yeah.
We need to hear from that. But what's a good way to respond?
Well, I think it really depends on the circumstance. If you have a strong case and you think that the judge is saying, and that happens a lot, the judge says, you know what, I don't need to hear it. And I say, Your Honor, you don't need to hear it? I don't need to hear it. Don't need to hear it, meaning I think he's going to grant the case. Okay, well, Your Honor, just for the record, we have his affidavit or the expert report. So if the government is stipulating to that expert report, Your Honor, government, then no problem. We don't need to call him. Government, you stipulate to everything in the expert report. And of course, a lot of times I thought that was a joke, twiddling thumbs. Am I right? Yeah. And I have friends who work for DHS. Memorialize all off-the-record agreements, restrictions, rulings for the record. Sometimes the trial attorney will agree. For example, I had a case recently where the trial attorney agreed that somebody was eligible to file a late application for asylum, and I wanted to make sure that that was on the record, not just that they told me beforehand, because I don't want to go to a next hearing, and then the next hearing says, Your Honor, motion to pre-remit from another DHS attorney. Because guess what? They have new attorneys every time you go to court sometimes. You notice that? All right. Closing argument. I'm going to speed up a little bit because I think we're almost done, but I want to leave time for questions. Take good notes. Do not waive appeal, okay? Unless it's fully favorable. Motion practice. Motion practice, I just give you some of these examples. I'll speed through them because you can see them. You have a copy of this and you can look at them. But these are some good ideas. And you may think, wait a minute, I can file motions? It's a BIA appeal. I thought I can just file a brief. No, here's a bunch of motions. Standard of review. So I gave you this is a quote from 1003.1. Just to remember, clearly erroneous test is when you're looking at findings of fact or credibility issues. And that's why if a judge is smart, if they really want to make their decision as ironclad as possible, I shouldn't say this. I'm sure they know this already, but I don't want to tell judges how to make my appeals harder. But if they want to make it really ironclad, they're gonna base it on credibility or their findings of fact. Because the IJ, the Board of Immigration Appeals, will not touch those or invalidate those unless there's clear error. This is very, very high standard. The board, however, may review questions of law. So make your issues about questions of law. Discretion. So interestingly, a lot of students, when I ask them this, what do you think the standard of review for discretion is? Now, discretion sounds like what? Sounds like weighing the facts, right? So you may think that must be clear error. Well, we have a little benefit in immigration law because guess what? Immigration law provides that the board reviews discretion de novo. So don't forget that. Make a big deal about that in your brief. The BIA does not have to have any credence, give any credence to the IJ's decision on discretion. And that comes up a lot because a lot of decisions are what? Discretionary decisions. Big point. And then all questions related to appeals from decisions of the service are de novo, which is good. Okay. The last few slides are just procedural, just so, if you're ever doing a petition for review, talk about that a little bit. BIA decision, when is it rendered? When it's rendered, when are they issued? Generally a few months after being completed, after the briefing is completed. But I've had cases that took, had one that took like 18 months in a non-detained case. The BIA tries to expedite detained cases. It's served on the client and the attorney. Should be served on both by regular mail. Keep track of the cases, EOR hotline, although in the asylum case, they won't even talk to you. They won't talk to you. Even if you're the attorney, won't talk to you. So there are ways around that, and you may have to just do what I've done in cases. I had one that was like 18 months pending. It was a BIA appeal based on asylum. I just kept filing motion for status of decision. Just tell me what the status is. And I eventually won the case, so I guess it worked. After the BIA appeal is decided, so I've done, my thing is petitions for review and appeals. And so the great thing about immigration law, if you win, DHS cannot appeal to the Fifth Circuit, which is kind of interesting. Okay, but if you lose, you can appeal, and that's under INA Section 242. If you're ever going to go to Fifth Circuit or any judicial review, even district court, look at INA Section 242. It's within 30 days of the BIA decision. You file a petition for review, which is very short. It's just basically, a couple pages. It's not like a brief. The procedures, the exact procedures on how to file it and who to send and this and that depends on the circuit, so be careful. Circuit court may not have jurisdiction over everything. Guess what? Circuit courts don't have jurisdiction over discretion. So the good thing is discretion is de novo in front of the BIA, yay. But in front of the circuit courts, technically, unless you can argue it's a question of law, they won't be able to review that BIA decision. So look at the limitations on what decisions the circuit courts will review. There's no jurisdiction over aliens who are removable for committing certain types of crimes. But remember, the circuit court always has jurisdiction to consider what? Its own jurisdiction, right? And that means if the guy's an alien or the person's an alien, or if they're an aggravated felon, or if they're deportable. Okay, so you always have jurisdiction over those issues. Also, even in criminal cases, the circuit court always has jurisdiction over, and this is why I always make my appeals about these two things, constitutional claims or questions of law. Because even if there's no jurisdiction, you can still argue constitutional claim or question of law under INA Section 242 ACD. Legal resources, I just put these in here because, these are some really good resources. Vendors is really good. Obviously, Practice Manual, AILA, if you want to use their resources, they have a great AILA docs and the InfoNet. There's also an EOR virtual law library. To be honest, I don't really use it. But it's true. It is pretty expensive, and if you're not, I'd rather use Lexis or Westlaw. But it also has all of the BIA precedent decisions, and then Immigration Law Advisor. And I'd say be careful, take it with a grain of salt because that's published by them too. Oil. So don't read it and say, oh, I'm out of luck, because they have their own newsletter about decisions. But I found that helpful. Okay, so we finished a little early. Any questions? Do we have time for questions? I know somebody does. Yes?
So what do we do in credibility cases? If it's an adverse finding on credibility, what are your suggestions?
Look for background issues. That's why I talked about background issues. No, I mean, credibility, obviously, there are some cases that talk about, if you look at Ira's book, and they talk about hearsay, and sometimes, like, for example, the judge will say, well, I'm not considering that affidavit because it's not credible. But, use the fact that hearsay is admissible, and, it depends why he's keeping it out. So he can't just keep it out because it's hearsay, for example. He can't just keep it out. I mean, there is something part of the Real ID Act of 2005 that says even if it's minor or immaterial inconsistencies, the judge can still consider it. But again, I would argue that if there's minor inconsistencies, and that's the only reason the judge is finding a lack of credibility, that they don't go to the heart of the case, right? They're not salient inconsistencies, and you still win on that basis. That's a good question. Anybody else? Any questions? None other? Good. Okay. Well, thank you. Let me just say, if you ever have any issues with appeals or petition for review or want to talk to us at the University of Houston, please call me or email me, and you have my information. Thank you very much.